Number 15, the people of the state of New York versus Reginald Wiggins.
Good afternoon. May it please the court, Ben Schatz for Mr. Wiggins. Your Honor, may I please have 2 minutes for rebuttal?
You may.
Thank you. The people of the state of New York deprived Reginald Wiggins his constitutional right to a speedy trial when they detained him at Rikers Island for over 6 years.
Counsel, what is the period of delay that we review here? Is it the period between the time when Mr. Wiggins was arrested and the time the first speedy trial motion was denied?
We would say at a minimum it's the period you just described, the period from the arrest to the point when the first, it's December 5th, 2013, the first speedy trial motion is denied. And we say that only because we don't think it really makes a difference whether it's 5.5 years or 6 years and 3 months. Both periods are extraordinarily long. Probably the better rule in terms of preservation on these types of issues is not to require counsel to repeatedly continue to make speedy trial motions once there's been a significant period of time.
What about the effect of the arrest and conviction, I believe, on 1 of 2 assault charges?
It's totally irrelevant here. It's irrelevant as a matter of law. There is a U.S. Supreme Court case called Betterman that comes down last year and says that even if a defendant is convicted on 1 count, he still retains his right to be speedily brought to trial on an unrelated count.
But does it affect the prong of the extended period of pretrial incarceration? I mean, it wouldn't affect your speedy trial rights, I could see that. But if you're factoring in period of pretrial incarceration, why wouldn't it go to that factor?
I think it's irrelevant to the totality of the Taranovich analysis, but as sort of a factual matter to look at the...
Well, the argument would be that you'd be in jail for on these charges anyway, so that instead of having 5.5 years, it may be 2.5 years.
Well, as to the pretrial incarceration prong alone, I think, respectfully, Your Honor, I think that switches cause and effect. The reason he is at Rikers Island in the first place is because he's being detained for so long. There is an assault committed at year 3 of his incarceration.
So clearly, then the first 3 years would be free of that.
At a minimum, I think our position is that the entire period of detention counts, because he wouldn't have been at Rikers Island had it not been for the case that he was.
In other words, even if he didn't commit those assaults, he still would have been there on these charges. Isn't that your argument?
Exactly.
Okay.
He would have been. He would have. The entirety of this period goes to one overarching point, which is that the prosecution made a strategic decision to effectively ignore Mr. Wiggins' case to focus on his co-defendant.
But that seems to me to not look at the factors. And one factor is the length of time. And granted, the 4.5 years, I think it is here, wouldn't go to the length of time. But in terms of pretrial incarceration, what if he had been convicted for fraud he had committed when he was outside, but he happens to be sentenced to that fraud while he's in Rikers? Would that count?
I'm not sure. I'm sorry. I'm not sure I understand.
But for the fact that he was at Rikers, he wouldn't have committed the gang assault. So let's say it's a crime unrelated to his time at Rikers. He had been committing some type of fraud while he was out, and he gets convicted of that fraud while he's in Rikers and sentenced to 4.5 years. Would that time count?
I think it's tough to parse. It's a different scenario. In this case, had he committed an assault and the instant case didn't exist, I think we'd...
No, but let's say the instant case existed, but he committed the assault before he went to prison, but they try him while he's in there.
Yeah, I think you'd have to look at whether or not he could make bail on the other
But what about the sentence? Wouldn't matter if he made bail or not, right? That's pre-trial time.
Yeah,
so
and
he's sentenced to 4.5 years. He's sentenced to 4.5 years. He wouldn't make bail.
Right, and the 4.5 years comes after a 3-year period where he's incarcerated on this case.
Then to count the 3 years, I think, as Judge Fahey was saying, but the issue is in terms of incarceration, why would you count the 4.5 years? Well,
so I guess another way to look at it is just to distinguish your fraud hypothetical. In this case, the assault on which he was convicted requires as an element that he is confined in a correctional institution.
What about escape? What if he escaped and he gets, well, obviously he wouldn't get the couple, whatever time he was out, but let's say he escapes and he gets convicted for escape. Would this same theory hold that, but for the fact that he was in prison, he wouldn't have escaped?
I think there are scenarios you can come up with where the pretrial detention shrinks depending on the circumstances of the crime. I don't think that's a case
You're
here.
not trying to incentivize escapes. Let me ask you this question. I'm a little confused from the briefing on this. How do the Taranovic factors differ from the Barker balancing test, if at all, in your opinion?
They differ in one way. This court's jurisprudence is broader than the federal examination in one way, which is that this court or New York does not consider whether or not the defendant pipes up about the delay. So in this case, he did make 2 constitutional speedy trial motions, but in the federal context, that is actually something that is looked at, the demand for...
I mean, the assertion of the right.
Right.
So you're saying otherwise the factors overlap.
Right. And so for the factors that count, I think we can look to cases like Barker versus Wingo, and the factor that's really important here, because it's one of the 2 factors that the lower court, the appellate division majority and dissent disagreed on, is prejudice, and the other factor is the nature of the cause asserted.
Does it matter whether we consider the lost opportunity for rehabilitation and all that under Factor 4 or under Factor 5? Does that make a difference?
No, it doesn't, and it's extremely, extremely important. The fact that the appellate division majority, no disrespect to the appellate division majority, did not consider the fact that Mr. Wiggins was a 16-year-old kid at Rikers Island for over 6 years is astonishing. It is wrong as a matter of law. It's crucial because not only does Mr. Wiggins have an interest in this speedy trial right, society has an interest in general in making sure that juveniles aren't put in those types of situations.
Mr. Schatz, what is the standard by which we review the prosecutor's conduct in the way?
The legal standard. This is a
Is it a deferential standard of good faith in?
No, not at all. You have to look to, I think good faith comes into play only to the extent that they're arguing that they didn't act in bad faith, but you still have to look to the objective justification for their action.
Take a step back for a second. Let's assume that there was good faith. You know, let's assume that the people legitimately wanted to use Armistead's testimony in a trial against him. I think we can all assume that, and there's certainly nothing wrong with that. That doesn't, they're doing their job. I don't think any of us would characterize it as bad faith for them to attempt to do this. The question is, isn't it really that even if they aren't wrong, if they are acting with good faith, when does it become a constitutional violation? Isn't that the question you want to ask?
That's the exact question you want to ask, and the answer is, it's answered by Barker versus Wingo. Barker says 4 years is too long to do the exact thing the prosecution is saying that they're doing in this case, which is trying to get the cooperation of a co-defendant to better prosecute a defendant.
So with all that was going on in this prosecution, mistrials, motions, if we were to agree with you, are we getting close to making a per se time rule here?
No, you're not. You don't have to say anything more than Barker says, because Barker says 4 years is too long. This is at least 2 years longer than what Barker says. I think it can be decided as a matter of law on all fours with Barker. This is...
Well, it really, I think the court should be concerned about that, and wouldn't we have to say in the context of the Taranovich factors that it was too long, and then do an analysis on a factor-by-factor basis? I don't think we'd ever want to say that there's some time limit.
That's completely right, and I was just making reference to the second cause factor in relation to the first cause factor, but the other factors, aside from seriousness, which no one disputes, cut in our favor because he was incarcerated for a very long time. He was incarcerated under these very sort of inhumane conditions.
What about a requirement for specific prejudice? In the last factor, you say he's been impaired by the delay. Do you need to show specific impairment?
That's the other sort of legal error made below. There's no requirement of a demonstration of specific prejudice. It's presumed when you're talking about a delay so extraordinary.
Mm-hmm. Thank you.
Thank you, counsel. Counsel?
May it please the court? Sabrina Beer, on behalf of the people. The determination that there was good cause justifying the delay presents a mixed question of law and fact.
Well, but is that even the determinative issue? It seems to me that the court below conflated CPL 3020 and CPL 3030. It seems to me those are two different things, and the appellate division seemed to use the standards that we use for one inquiry into another, and they don't seem to fit that well to me.
Well, Your Honor, the appellate division's reference to 3030 wasn't to suggest that 3030 was dispositive of this issue. It was simply to suggest that 3030 was drafted in order to protect the right to a speedy trial, not to curtail that right, and therefore the exclusions under 3030 are certainly indicative of time periods that are reasonable delay. Like here, the appellate division found that the reasons justifying the delay were reasonable. And to go back to the
But that doesn't end the inquiry, whereas under 3030, it's an additional protection or right that you're giving the defendant, and there are specific time periods. It's about the people not doing certain things to delay.
Well, of course, Your Honor, but here the good cause analysis isn't just the second factor or the reasons for the delay. The good cause actually is the Taranovich balancing test. As this court found in Vernacci, that balancing test...
So are you saying then that whenever there's an absence of bad faith or there's a legitimate reason, no matter how long the delay is, it can't possibly be a constitutional speedy trial violation?
Absolutely not.
So what's the question then? Is that if I'm operating under the notion that the people had good faith. There's no mixed question here. I'm assuming you're acting under good faith. You want to get somebody to testify against someone accused of murder. There's no bad faith in that. You think that's dispositive then? That you could hold, how long could you hold someone for, even if you have good faith?
Well, Your Honor, the people's good faith is
but
not
no, answer my question. How long could you hold, assuming the people have good faith, how long can you hold someone before you bring them to trial?
Well, there is no bright line rule, but...
Give me your estimate. Is there a limit? Is there any limit?
It depends on the balancing of all the factors.
Could you hold them for 20 years?
It depends on the balancing of all the factors. If the 20-year delay were solely caused by the defendant...
Let me finish. I'll let you respond to. You see the absurdity of the position is that by assuming good faith, which I think we can do here, it can't be a limitless good faith. There has to be a time period beyond which no matter what the person's been charged with, you got to bring them to trial, no matter whether you're going to be successful or not. You can't look for the perfect case. You have to go with the case you got. And so you can't argue the absurd position for us that we get to decide how long we can hold someone before we bring them to trial.
Of course not, Your Honor, and that is not at all our position. Our position is that in evaluating the second factor, the appellate division had reason to find that there was good faith, and that balanced with the other factors, including the fact that defendant was charged with murdering 15-year-old Maurice MacIver, and the other factors such as the fact that defendant, while he was incarcerated for the pendency of this case, was indicted on 2 other violent felonies.
So how many mistrials, how many times could the prosecutor have continued to try to convict the co-defendant in order to get him to testify against this defendant? Is there no end to that?
There is, of course, an outer boundary to that.
Well,
it just wasn't reached.
Why wasn't it reached here?
Well, it wasn't reached here because of the balancing factors in this case. Again, defendant was indicted for murder in the second degree.
I guess to go to Judge Stein's point, and I think what Judge Fay is saying, is at some point, retrying this other person becomes bad faith in a way, because it seems to me you go forward with this charge, and you should be prepared to try the case. I mean, it may get better. That'd be great for you, but as a prosecutor, you bring this charge, you're prepared to prove it. Otherwise, you wouldn't indict this case, I assume.
Of course.
So at some point, the need to add to that mix of proof you have, when by filing an indictment you've represented you're prepared to try it on what you had in the grand jury or what was available, when does that become bad faith?
Well, there certainly is a period in which that does become bad faith, but again, in the context of this case, that period just wasn't reached.
Because what?
I'm sorry?
Why?
Well, again, this is a delicate balancing of all the Taranovich factors.
Right,
And
but just looking at that one factor of good faith, why haven't you reached the point where, the tipping point where this is bad faith? Now, you've tried this guy, this potential witness, a number of times. You haven't been able to convict him. You've indicted someone on the theory that you can go forward and prove a case beyond a reasonable doubt. When does that become bad faith?
Well, again, Your Honor, there is a point in which it would. And actually, if I could direct this court to Barker, it appears that in Barker, that court found that the pursuit of the co-defendant's testimony over 4 years, while they didn't use the phrase bad faith, they said that that was unjustifiable. But in light of the counterbalancing factors in that case, there was no speedy trial deprivation.
Bottom line, you just want us to look at the gestalt of all the factors and, let that go.
Well, again, I would assert that the people did act in good faith, and throughout the pendency...
The thing is, the reason that he wasn't tried in this case wasn't because of the two assaults. One he was acquitted on and one he wasn't. It wasn't because of those at all. So that factor, I think it enters into the mix, but it's far from dispositive. The dispositive factor is the testimony of Armistead, right? That's the key element. That's the reason that he was there for that period of time.
I would say that there is no factor that is dispositive, but it's certainly relevant.
Is there anything other than Armistead that held you up in bringing the case to trial all those periods of time? That entire 6 years, 3 months, and 25 days.
As a matter of fact, the defendant himself requested several adjournments.
7 months of
And you had
adjournments.
how many different DAs on this case?
The assistant district attorney did change twice during the course of the litigation, but the people were pushing defendant's case forward. Discovery practice went until March of 2009.
So let me try this question for you, because I think this is where I'm stuck. What, under your rule, your approach, your reading of the law, the people's position on this, what do you see as the factors, and I know we're talking about a lot of factors, but for this particular issue, what is it that the court should use as a guide to determine the reasonableness of the people's choice to continue to try and get Armistead to flip and turn and testify against this defendant?
Well, that's just it. It is a reasonableness test. And
yes, and what are you saying under the law the court should look at?
Well, the court should look at, for instance, the fact that the defendant never alerted the people that he was suffering any harm beyond that what could be.
No. That has nothing to do with whether or not you're taking more or less time to pursue Armistead for purposes of getting him to testify against the defendant.
Well, it does go to the reasonableness of the people's approach. As the Supreme Court said in Barker v. Wingo, the more, and of course this court doesn't consider his demand as a factor.
How is it the defendant's counsel telling you what's obvious, that he spent years in Rikers, is detrimental to him, affect your deciding whether or not I'm going to stop waiting for Armistead, who says I'm never going to testify against this defendant, to actually testify against the defendant?
Is it the nature and gravity of the offense?
The nature and the gravity of offense certainly attributes to the reasonableness of that. And the fact that defendant...
But that factor is never going to change here. So it never changes. I mean, we know that goes against the defendant, and we know it's a very serious crime. And certainly we all agree that to a point, it's not a constitutional violation to have the people pursue this attempt to make sure he's convicted. But you are saying that it's the other factors that tell us really when we reach the point of no return, so to speak, right?
Of course.
Okay, so presumably if it had been, a low-level misdemeanor, we wouldn't be here having this conversation. But
exactly, and the reasonableness of the people's actions has to be viewed in light of all the circumstances of this case.
But the seriousness of the crime, it's on the people's side, but it's also the complexity of the case, is it not? And what made this case so complex? You've got all those eyewitnesses. Well, isn't it, again, as Judge Fahey has asked you several times, that you're trying to get this one individual to somehow strengthen your case?
respectfully, Taranovich
While
said-
someone is rotting in Rikers.
Respectfully, Taranovich said that the complexity of the seriousness of the charge matters not necessarily because it would take more time to figure out the defense, but because the people have a responsibility in cases like this where someone is charged with murdering a 15-year-old, that they have to take deliberation and consideration.
By its very nature, the point of that is that deliberative process, that process to act cautiously and carefully. Yes, you are correct, of course, to try and secure a conviction, but it has to be in the context of the nature of your prosecution.
Yes, absolutely. And sometimes...
Let me try it this way. If the witness that you're trying to get to cooperate says to you, day one, no way, I'm never going to flip, because snitches get stitches, I'm not doing this, you know, at that point, is it still reasonable for the people to pursue?
That would certainly make it much less reasonable, but that's not what happened here.
Exactly. So what did happen?
What happened here was that the people were pursuing good faith efforts with the co-defendant, and he continued to meet with them. And they pursued those efforts until they presented him with a cooperation agreement, which he rejected. And they immediately announced their readiness to go to hearings and trial so that they could have the Huntley hearing and determine whether the cases needed to be severed. Because at this point, the cases were still joined, and the people had every duty to bring the best case possible against both defendants. And strong public policy suggests that co-defendants should be tried together. And I see that my time is up. I would ask this court, in light of the seriousness of the offense and the defense's failure to allege any harm to the defense case whatsoever, balanced with the other Taranovich factors, please affirm.
Thank you, counsel. Counsel?
Very briefly, page 184 of the record, the people specifically noted the effect of all of the repeated adjournment requests on Mr. Wiggins. So there is a concession by the people that their conduct, by focusing solely on Armstead's case, is impacting Mr. Wiggins. And this was in 2012. It was 2 years before his plea. So there were still 2 years after that. And the only thing that had happened to Mr. Wiggins' case during that entire 6-year period, essentially, was that they litigated a constitutional speedy trial motion.
What about the fact that you know, you had young witnesses, a lot of time was going by, memories fade? I mean, I don't think I think that's just common sense, but does that work for or against either the people or the defendant? Because it doesn't work.
It works for us.
Against both?
No, it works for us, absolutely, because what you have to do is get these guys in the courtroom and have them testify. If you don't try Mr. Armstead for 4 years, it's no surprise that
so
none of these witnesses are going to remember anything.
That's not part of your prejudice argument, then?
No, I mean, I think there's nothing in the record that says I've lost a witness, that sort of thing. Our prejudice argument is about what happened to Reggie Wiggins.
What about what your adversary just said at the very end about, you know, Armstead doesn't really unequivocally say, I'm not going to cooperate until well into this, and at that point they immediately announce ready once the judge grants the severance. And how much of this is really on the trial court for sort of just not ruling on the severance motion?
So 2 points. The first is that there's no support for that. The narrative you just described, what happened essentially is he said, I will never, the only facts we have are that Armstead said, I will never cooperate, and he repeatedly said that. And then there is a line in the trial ADA's affirmation that says, although he wavered on that. We don't know when he wavered. We don't know how much he wavered. The fact that
should there have been a hearing maybe to figure that out?
I mean, it's not necessary. As this is the prosecution making an affirmation that says that their potential cooperator is not going to cooperate, and repeatedly saying that. I don't know that there needs to be a hearing, but ultimately the burden is on the prosecution the whole time. So regardless of whether he's wavering or not, to spend 2 years trying to get him to cooperate, it all goes to that delay is all attributable to the prosecution.
So under your approach, what is it the court has to focus on to determine the reasonableness of the people's continuing to try and get Armstead to testify against the defendant?
Well, I think this is a strange circumstance because Barker has already told you, basically, there's a period of time that is unacceptable, and that is 4 years, and we have much longer here. So it might vary depending on the reason proffered, but the reason proffered here happens to be the exact reason that was offered up in Barker, and the delay is much longer here, and in that case it was for an essential co-defendant, and here it is a co-defendant that they can at best say would make their case better. So I think Barker is on all fours, and with that we'll rest on our briefs. Thank you.
Counsel.